Hey everyone, Paul Vojchehoske, your real estate instructor. My goal in life is to keep you out of real estate jail. All right, this video is going to be covering the lead-based paint documents. Lead-based paint disclosures are required for any home that's for sale or for rent, for options, involved in any transaction where the home is built prior to 1978. Okay, I have just a little bit of sidebar here before we get into this to illustrate how important this form is. As an investor, as a real estate managing broker, I can tell you there's no form in real estate. There is nothing in real estate that scares me except lead-based paint issues. And I'll tell you why. As tragic as it is, if I own a rental property and there's a fire and my tenant dies, it is tragic. However, I have insurance. I have enough insurance that's going to be able to cover any losses financially that I may sustain or otherwise. The problem with lead-based paint is, number one, most states, your errors and omissions insurance will not cover any aspect of enforcement. Number two is they call it the CERCLA law, C-E-R-C-L-A. I'll spare you what the acronym stands for. But it allows the federal courts to dissolve things like LLCs and S corporations and those type of things, to go after people's personal finances, to punish them for children, for example, that may have they've sustained some kind of injury due to lead-based paint. Now, I don't want to minimize how important this topic is. Lead-based paint is very important. It's very deadly. It is very, very harmful to humans and pets. It takes very little amount for that to happen. I understand all that. We're not going to get into the risk, the lead remedies and those remediations and those type of things. We're only going to get into what's required from you as a real estate agent or a property manager or landlord regarding this form, how to complete it, and so I want to start with this. This is the easiest form that I have found in most real estate packets to complete. It is very simple. Follow the directions precisely as they are on the form. If you do that, there is absolutely no issues if the auditor comes knocking. Okay? Now, what we're seeing here is that there's a couple of different forms throughout this video that we're going to be looking at. The first one is the lead-based paint disclosure for the buyer-seller. We're going to be looking at the lead-based paint disclosure for the landlord and the tenant. We're going to look at the Protect Your Family from Lead brochure, and then also what you need to have in your lease agreement. Okay, so let's get started. First of all, I want you to understand how an audit happens. Whether you're a landlord, whether you're a real estate broker, it doesn't matter. One day unannounced, the auditor is going to show up from the EPA. They're going to show you identification, and they'll say, I want to see all your real estate transactions on the rental side, the sale side, whatever, for the last 3 years. The EPA only can go back 3 years. Okay. The first notion typically is the first instinct is to say, sorry, talk to my attorney. Well, if you do that, they're going to hand you this nice little business card to their office of counsel in Chicago, where you're going to be able to call an attorney there and say, you know, what's up with this? And they're going to inform you that, quite frankly, if you don't comply, you're risking obstruction of justice. You have a right to your day in court. You have a right to due process, but it is post-investigation, meaning you must comply with the auditors, show them what they want. Then if you disagree with any findings that they may put on the notice of violation, if you get one, then you have your right to due process and go to court. It's sort of like if you get arrested, it's not the cop's job to adjudicate guilt or innocent. Their job is to write you the ticket, and then if you don't agree with it, you can go to court and fight it. Okay, that's the first thing you have to understand. So if the auditor knocks at the door and shows up, comply. That's the first thing. The second thing is as they go through the files, we want to make sure that from a risk management point of view, there are no issues that they can write you up for. Now, having said that, I need you to be very, very clear here. I have a ton of experience through my consulting business dealing with EPA auditors. Every auditor has their own interpretation of what things should look like and how they should be filled out. Okay, so I'm giving you the general baseline here. All right, so keep that in mind, and as I'm going to illustrate this as this goes on. So here's the first thing. We're going to deal with the lead-based paint disclosure for the buyer and the seller. This entire form comes from the Code of Federal Regulation. You cannot change it in any way. You want to make sure that you're using the most up-to-date disclosure form. That's the first thing. I typically get mine right from the EPA website. All right. If you're doing a sales transaction, make sure you're using the right form. If you're doing a rental transaction, make sure you're doing the right form. Failure to use the right form can be an $11,000 notice of violation. Now, here is the lead warning statement, which is required to be on this document. Okay. Oh, one other thing. Under the code, and most auditors have this opinion, and that is you cannot write on this whatsoever anything that's not already, basically fill in the blank. You cannot put a form number down here or nothing. If you do, that is a potential notice of violation. There was a big deal with the office in Kansas City a few years ago where they didn't even want you writing the property address on this form. Obviously, we all know the issues with that, but I will tell you that as a general rule, you're usually allowed to put I recommend you put the address on here, so then you can obviously match the form with the property. So let's go through here. This is the seller section. The seller has, under the Code of Federal Regulations, certain duties. The purchaser has certain duties as well. The listing agent has duties, and then the certification of accuracy. We're going to talk about each one of these step by step. Excuse me. Let's talk about the seller. What's the seller's duty? The seller's duty is to answer A and B, and then provide any documentation or known hazards. That's their duty. So the seller is going to, and let's read that. This is very important. Let's look at A. Presence of lead-based paint and or lead-based paint hazards. What does it say to do? It says to check I or 2I below. So that means we need to check here or we need to check here. I have actually seen numerous notice of violations from auditors that said that had where the landlord or the seller had put an X or they put an initial, and they were giving a notice of violation because they did not complete the instructions. Okay, so the point I'm trying to tell you is this form needs to be completed exactly as it says here. If it says put a check, we put a check. If it says put an initial, we put an initial. All right, so the seller's disclosure. Let's look at I, AI. Known lead-based paint and or lead-based paint hazards are present. That is not a presumption. Do you have actual knowledge that there is lead-based paint in there? Actual knowledge comes through testing. If you've never had it tested, you only have hearsay. There is no actual knowledge. And the fact that it was built prior to '78 does not reach the threshold of disclosure in and of itself. Let's look at the second one, or the seller has no knowledge of lead-based paint. Typically, that's the one that is checked. B, records and reports available to the seller. What do we do again? We check. The seller has provided the purchaser of all available records, or the seller has no records. Again, the seller puts the check there. I want to jump down here. If you're the listing agent, you represent the seller. Your obligation, and this part here is for the listing agent's initials, because what does it say to do right here? It says initial. The listing agent, their duty, it basically says that they are confirming that they have informed the seller of their obligation under 42 United States Code section 4852. What is that obligation? To fill out this part and provide any reports. That's really it. So your job as the listing agent to say, hey, Mr. or Mrs. Seller, we need to complete this. All right. Real quickly, if you co-list, this is all about what's on your listing contract. So if there are 2 listing agents, then there has to be 2 initials here. Otherwise, you risk an $11,000 notice of violation as of today. Those fines can change. As of right now, it's 11 grand. All right. 2 listing agents, 2 initials. All right, let's go up to the purchaser side. Now notice here, it kind of switches. The purchaser's acknowledgement. What's the purchaser have to do? They have to initial. So we went from checking up here back to initialing. The purchaser has received copies of all the information listed above. What does that mean? The purchaser has received any and all information provided by the seller here. The number one question I get on that form is, what should go here? What do they mean by that? Well, I can't answer that for you. As a broker, as a property manager, landlord, you're going to have to make a decision. I've seen some auditors, and I've talked to some auditors, and I've talked to 2 director of enforcements in 2 different EPA regions. Some take the position that whether there are reports or not, they still are acknowledging that they've received this information above, that there is no reports. Other auditors say you put NA or leave it blank if there are no reports. It really is that subjective. Unfortunately, I can't give you an answer, so you're going to have to talk to your broker, or whatever you do, be consistent with it. D, the purchaser has received the pamphlet, Protect Your Family from Lead in Your Home. That is this pamphlet right here. Now, a couple of things. Number one is the versions change all the time, so you want to make sure that you're providing your client, your buyer, with the latest version. If you give them the wrong version, that's a notice of violation. That's the first thing. All right. Secondly is we want to make sure, I'm sorry here, let's get to the buyer seller. There we go. We want to make sure that we give it to them, and notice it says purchaser has received. If there are 2 purchasers on the purchase agreement, there must be 2 initials. 2 purchasers, so if there's 3 purchasers on the purchase agreement, then there has to be 3 purchasers. And I'll tell you why. I have actually seen notice of violations from clients from the EPA that there was only 1 purchase, or one initial here, and there were 2 purchasers on the purchase agreement, and they were given a notice of violation because they were missing an initial. And here's the kicker. They were missing an initial on C. That's 1 notice of violation. They were missing a notice of violation, an initial on D. That's 2 notice of violations. See how that works? And it's all at the discretion of the auditor. You could literally, on 1 transaction, literally could have hundreds of thousands of dollars in notice of violations. I've actually seen it. All right, so let's go to E. E now. Notice we're back to check, not initial. The purchaser must check whether or not they want to have the 10-day opportunity to have a risk assessment done, or they're going to waive it. A couple of things here. Number one, it's 1 check. If there's 3 purchasers, we don't need 3 checks, only 1 check. That's one thing I can tell you. Secondly is, it is not an option. The buyer has the sole and exclusive right under the code to do this. Now, what can be negotiated is that 10-day opportunity. You can negotiate a 3-day, 7-day. The buyer and seller can negotiate it. I just want you to understand this. A buyer or a seller cannot under federal law turn down a purchase agreement from a buyer because they are asking for a risk assessment. Let me repeat that. Federal law protects the buyer. A seller cannot reject a purchase contract from a buyer solely because they want to have a risk assessment. All right? What you have to do then, if you're on the list side, is come up with another legitimate reason to reject the offer. The law does say that if it's a multi-offer situation and one does have a request for a risk assessment and one does not, that the seller can legally take the one without. But if it's only 1 offer and they are asking for it, they cannot. So keep that in mind. Very important. All right. We already talked about the agent's acknowledgement. Now let's go down here. The certification. Certification is very important. It's this is where everybody signs, and this is typically where I find the mistakes, if there are any. Everybody, how many sellers sign this document? All the sellers. So if there are 2 sellers on the listing contract, then we need to have 2 sellers here. If that LLC has 5 members and there's not 1 member that is the signature authority, so all 5 have to sign, we have to have 5 signatures here. Failure to have those signatures, each one that's missing can be an individual notice of violation. If there are 2 listing agents, there has to be 2 listing agent signatures, and then obviously the buyer's agent has to sign this. The point is be very, very detailed on this form. I cannot emphasize that enough. It's very important. That's all we're going to talk about here. That is the lead-based paint disclosure form for the buyer and the seller. My next video is going to be the lead-based paint form for the landlord tenant. So once again, I'm Vojchehoske. Thanks for joining us. Until next time,